couple of important provisions which are there in right to information laws in other countries for both records management and proactive disclosure. The information commissions in other countries, and in South Africa it's the Human Rights Commission, they have been given responsibility for developing guidelines on how 411 must be done, and then vetting the actual proactive disclosure done against those guidelines, and then suggesting improvements. So this is a measure that is seriously lacking here. In the context of disclosure of information, I think the case which Mr. Mishra has suggested is so much in tune with what is expected in the Public Records Act of 1993. It says there will be a record creating agency and that will be responsible for the maintenance and management of records. So in that sense, you don't have to define anybody as a public authority. That record creating agency, if it has created and held records, then that becomes responsible for the maintenance of those records. But sadly, this is a law that applies only to Government of India. It is not extendable to the other states. It's a central legislation, unlike the RTI, which is applicable to everybody else. So if those states do not have their own records management laws, then it has become a problem. Norway has recently started something very interesting. The government has set up a huge portal where every department is listed. Sadly, right now it is in Norwegian language, but we got to know about it through other people who understand Norwegian and speak Norwegian. Every department lists every single file that is maintained, the topic of what that file is, and it is publicly, the list is accessible. Sweden started something like this a few years ago, and there they said, next to each record and its name, whether something is publicly accessible or not. You can challenge whether it is not, if it is not accessible, you can challenge it later. But at least that information is available in the public domain. It makes this business of making targeted applications so much easier. So if that's something that can be developed, and here I want to make this linkage with what the President of India said in her inaugural speech to the Lok Sabha, the joint session of Parliament last year, that there will be an open data sharing, open data policy, public data policy. All non-strategic information will be placed in the public domain. This is a promise, and recently we will amend the RTA because of that. Today, the interesting thing is that responsibility has been taken away from DOPT and handed over to Department of Science and Technology. So the development of this national data sharing and access policy is in the hands of the Science and Technology Department. There is absolutely no information in the public domain as to what is going on. And this is where the travesty, and that's the last point that I want to point out, that matters relating to the administration of RTI are being done in such secrecy. The single biggest example, of course, we've discussed the Information Commissioner's appointments. Now, the other example is the drafting of rules. We know from the Central Information Commission's website that the DOPT has given them some draft for consideration and comments, and they are about rules. We don't know what's there in them, and the minutes of the Commission's meeting says it's been given to them.
We can ask them.
Arvind, let me complete. I don't want to put any of the commissioners into any difficulty. I only want to point out this process of lack of transparency from the administrative ministry. So our request to the commission is that if they have already sent their comments, then probably a follow-up letter can be done. If comments are still being prepared, then probably a recommendation must be made to the DOPT saying that please open this up for public comment. If there is anything negative, then let people come out with, because people are the ones who are using this law. It is not the government which is using this law, unlike all other laws. So people should have a right to comment. So a request is, can the commission please consider this, the Central Information Commission, and similarly to all the other state information commissions, whenever there are laws, when rules are being made, then they must be subject to previous publication before final notification. There is a requirement of this kind in the General Clauses Act. It's just that it's not followed. They did that in the context of NREGA when the Central Council rules were drafted. The draft was put up and then time was given. The interesting thing was, because all the concerned stakeholders were involved in the drafting of the draft rules, when the final notification was done, there was a line actually which said there that we have not received any comments from the people, which means all the comments had already been put in when the draft itself was prepared. So that was a beautiful process, although I was not part of it. So I think something similar has to happen in the context of any rule drafting in the context of the RTI. Thank you.
Okay, next. 2-3 quick points. First of all, there is a judgment of the full bench of the CIC, which you should know about because it's Venkatesh Nayak versus DOPT, where they have held, the full bench has held that all laws, draft legislations, policies, etc., till they become cabinet notes must be shared. So obviously this As I don't think the rules will ever go to the cabinet in any case. I think it is certainly in the public domain. And my suggestion is that we should ask the DOPT in any case, if they haven't already put it up, put to under RTI and give it. You mentioned two other things. I just want to quickly. You said that there is a lacuna in our act because it doesn't have the provisions that the South African Act has. That every public authority has to make this manual of disclosure, which has to be vetted. Now, as you probably know, what happened in South Africa, and I mentioned this in passing yesterday, is that they had something like 250,000 manuals which were presented to their commission. And when I last heard, the commission had only gone through about 11,000 of them, and they were still. So we purposely didn't make this because, if South Africa had 250,000 public authorities, and if we take K.K. Mishra Saab's definition, we must be having at least 5 million public authorities in this country, perhaps more. Then it is an impossible task. So we have to come up with something more practical for the Indian situation. The other thing that I just want to mention to you is that we need to discuss this. I mentioned this to Colin, but I disagree with this viewpoint that PIOs cannot be given the responsibility of servicing Section 4. And I think there are provisions in the Act which can be interpreted to do that. Because actually, you see, why are we so scared about what the High Court will say? Let us interpret the Act as a commission. If the High Court says no, okay, it's on them, their head. But at least we should interpret the Act boldly. And then you never know, one judge might say one thing, the other one might say another thing, the Supreme Court might say a third thing. So why should we worry about that?
Any other comment?
The only thing is, you asked the PIO and he said this information does not exist. Now again, he will say, this information has to be created and it has to be created by somebody else. I can't create it. How will you respond to that?
No, my point is this, that if there is information that the Section 4 1B prescribed which is not existing, fair enough, that's a separate issue. I would also agree with the point made by the IC of Karnataka that as far as possible we should have the resources to be able to give this out. In fact, one of the points that I think the Information Commission, Central Information Commission themselves have put across is this, that we should have a negative list. Each public authority should be asked to make a negative list of what are the files which could possibly contain material that might be exempt. Now, the assumption is that if you do that, most departments of the government and therefore most public authorities, 95% of the files will not come under that list. Now those 95% must automatically be scanned and put out, etc. And here, if you can get a third-party agency to do it, and for example, in the United States of America, the function of the PIO is not performed by a serving officer of that department. They have a parallel structure who performs that function. I won't go into details, but it's a very well-devised system so that the officer cannot say, look, I'm very busy and I'm not being able to do it. Of course, it works better there because everything is computerized, etc., etc. So you can, at least this 95% can be put out. Now the great other advantage is that there, if a request comes for information relating to these 95% of the files, there should be no question of examining whether it can be given or not. So that would reduce the workload, because you see right now what is a public authority say? We get 10,000 applications in a year, we have to examine each. Suppose you find 9,000 of those 10,000 are relating to matters which have already been declared as open matters. Where is the matter of examination? There isn't any. So I think all these things need to be done, and I would say that the Information Commission, the two issues, I would say particularly the Central Information Commission has to play the leadership role in this. Because as all bad things emulate down from Delhi, let some of the good things also go down from, that all the High Court rules got ruined because the Delhi High Court ruled. Let the CIC take the lead on this and then informally talk to other information commissions.
I like the example that Shailesh gave in the beginning. He gave the example of ration cards, which is food. He then gave the example of free beds, which is healthcare, right? And I think sometimes if we understanding that there are thousands and thousands of public authorities, if we focus in particular areas where information critical to the poor has to be proactively disclosed, we may not go rambling all over the place, but focus on very specific data. One. Second is, I also accept the point that he made, that he feels a sense of frustration that we are not following up with certain ideas that he has. And I have a feeling that's because there may be a slight disjunct between the Commissioner's office and certain campaigns and movements. Now, as a Right to Food campaign, I'm not sure whether we were really engaged with you in a systematic way, because we have been perplexed by that issue of transparency and putting up. We've just got the order for the computerization within 1 year of all the BPL cards. We've just got that order. And a special agency is being authorized to computerize all BPL AAY cards in the country. So everything is going to be on computer, right? And as I told you, we got this order for the dissemination of court orders and schemes and so on. We've got that. So it might be a good idea to get the Right to Food campaign to sit with you and work out proactively a kind of strategy where you can also use the right to information proceedings for proactive disclosure. And similarly in health, free beds, for example, that case is going on in the High Court now, in the Supreme Court. And Swatandra Kumar, the Chief Justice, when he was sitting at Delhi, passed a stinging order against hospitals, including private hospitals. And that has gone to the Supreme Court and has stayed. So that issue of free beds is a live wire issue. And finally, I don't think there is no sanction really. Because if on a simple application somebody applies to the PIO, give me the list in my slum area of the BPL cards, that matter somehow comes up to the commission in some way, then the PIO is told to take the advice of the CEO of the food department or the food ministry, catch the top man as a deemed PIO. Is it not possible to catch the top man as a deemed PIO? And then say, we passed an order. Originally the PIO was involved. We have directed him to take the assistance of the Secretary Food Department. He has not complied with proactive disclosure. We'll penalize you now.
I believe it is. I believe it is possible to catch the highest person. In fact, in Maharashtra, I had asked for action to be taken against the Chief Justice of the High Court. The Commissioner would
really
not
start from the top. Huh?
Yeah, might well start from the top. And incidentally, that time Swatandra Kumar was the Chief Justice.
So if there are no more comments or questions, then I would like to request the chair to wind up the session. Thank you.
This has been a very interesting session, and the first part of this session where we discussed the process of selection of information commissioners, I think it was a very good sign that the information commissioners themselves, all of them, as Mr. Mishra in fact beautifully put it, he said, how can you argue against the truth? So I think that's the spirit. One thing I must say, earlier as an activist and now as a commissioner, compared to most other commissions